Hello, I'm Wilson Cole, and I am president of Adams, Evans, and Ross and Baker Hiring Solutions. And I want to talk to you guys about basically, we talked a lot about what we can do through collections. The good news is 87% of the time we're going to get it collected for you through the collection process, typically within that first 30 days. There's about 13% that wind up being recommended for suit. And out of those, about 80% will pay before we ever get to court. There's a negotiated settlement, both client and the debtor agree, and it gets resolved that way. About 10% of the cases, the companies go out of business, file bankruptcy, whatever the case may be. We have to enforce about 10% of the ones that we sue as far as on litigation. And I want to take a few moments and discuss some of those options are, because a lot of clients don't realize that before you can go file a lien, before you can go attach assets, before you can go seize checking accounts, you have to get a judgment. Now, once you get a judgment, you are given some tools. Typically, it varies from state to state, but most states have a garnishment provision in their enforcement of staffing and recruiting, or just in judgments in general. And so once we get a judgment, you can go and attach their checking account at times, where basically the court sends in a notice to their bank and says, hey, this is a judgment creditor, any funds, please send up to this dollar amount. So if there's $100,000 in the account, they owe you 30, it freezes their account for 30 days typically. And then at the end of 30 days, the $30,000 is sent to the courts to satisfy, in this example, our client, and then the other $70,000 is released back to the debtor. Another thing that you can do is you can attach receivables. There was a situation where there was a company that was out of state. Our client had sued them. I believe we sued them in California. And through some investigations, we saw that some larger top 100 companies were customers, and they had mentioned in some press release the work that they were doing. We were able to get with the attorney, forward that information to it, and he sent out a notification to those companies and said, hey, we're a judgment creditor. Any funds that are owed, you need to send through the courts. And so we were able to get them resolved that way. So there are varying degrees of being able to enforce. As a general rule, we will go after checking accounts first, receivables second, and third, there was a boot shop, I believe in Texas, of all things. And they literally, the sheriff, you can do what is a sheriff's seizure, where the sheriff goes out there, padlocks the door, brings in a truck, and carries off the boots. So we were able to resolve it that way and get our client paid. The interesting thing is that the sheriff didn't have to take off all the boots before they could load up the entire truck. Lo and behold, the debtor was able to process a check for $10,000 or $15,000 or certified funds to give to the sheriff. So there are certain things that you can do. Now, what is true in one state isn't always true in another. One of the things that we have done, it's very rare that we will recommend suit, for example, in the state of North Carolina, or state of South Carolina, because it is a non-garnishable state. So you cannot attach their checking account, you cannot go seize assets, and so basically the courts say pay. And if they still don't pay, you can bring them back in and the court says pay. And if they don't pay, they're not going to throw them in jail, because this country eliminated debtors' prisons years ago. So sometimes it can become much more enforceable in states, and much less enforceable in others. So you need a partner that understands the different areas you're going to have the best chance of collectability. We can also bring in local attorneys from that market. We've done this for, so we know where most of those issues lie. But we can also get an opinion before we go to suit. If there's some unique cases, we get an opinion from the to be litigating attorney from that specific state. A lot of times companies will use a local attorney, which is fine, But they'll file suit if the company's if they're in Florida, their attorney's in Florida, they'll go ahead and file suit on a company in Oklahoma. Don't have assets in the state of Florida. In that example, you're still going to have to domesticate it, which means you're going to have to sue them all over again in the state of Oklahoma. So just be careful. Make sure that whatever attorney you're utilizing, ask them, A, are you going to be able to enforce the judgment? And B, what does that look like? Run into most issues where attorneys aren't able to enforce a judgment is when they sue in their client's home state, but the debtor's in another state. You still have to domesticate it. If we can help you, or if you have a situation that you'd like to discuss with me or one of our staff attorneys, please go to staffingdebt.com and book a meeting. If you'd like to look for backdoor hires with our software, go out to backdoorhires.com and book a demo, and we'll run that through for you as well. But just remember, not all's lost, because once you get a judgment, you do get some teeth to be able to enforce that judgment. Hey guys, it's Wilson again, and this video was brought to you by Adams, Evans, and Ross. And if you like the video, please make sure that you click on the subscribe button and also like the video. If you have any questions or comments, please leave those below as well. If you'd like to learn more about our company, please visit our website at staffingdebt.com. And also remember, if there's no collection, there's absolutely no cost at all.